Good morning and welcome back to the last session of our course on legal aspects of aviation financing, leasing and financing. I hope you enjoyed the speaker from Arthur Cox. It's very fortunate that she agreed to give us time, and I was sorry I wasn't available to be there, but I think in fairness it will have been worthwhile. Because of my absence and also because of the slot taken by our guest speaker, Miss Devlin from Arthur Cox, we need to put some of this material onto the video streams that I've already alerted you to. All right, getting straight down to it, this is session 4. We're going to look at two basic concepts. First is we're going to look at the liability of the financier and the lessor in aviation financing and leasing. This will include a brief overview of the allocation of risk through contractual provisions, non-contractual liabilities on the parties, including statutory provisions, particularly those which arise as a result of the Cape Town Convention. The second aspect in session 4 will look at disputes which arise in these sort of contracts and how we can enforce the agreement itself. The disputes normally arise through a breach of contract action, and in that sense we'll be looking at the options available to you, in particular obviously judicial remedies, but also those of arbitration and mediation under the Cape Town Convention. These are non-judicial remedies, and some of them in fact may cross over to almost self-help type remedies. We'll also be looking at the role of the High Court in Ireland. Ireland is the home of the International Registry. Our judicial system plays a role in any disputes which might arise with respect to that. Okay, let's go into this as quickly as we can. You may recall from last time we had finished off on the basis of taking a security interest in the aircraft and using the contractual process to do so, and then looking at the provisions of the Cape Town Convention to see how we might protect that interest by registration. Registration gives you priority, and registration is a way of ensuring that your security interest is valid, as we talked about, erga omnes, against everybody. But wait, what if it's all gone wrong? What do I do now? This is where we're going to move the story on a bit, and we're going to look at the issues of what remedies are available on default by one of the parties. Where do I go to now? Well, it's a good job I had thought about it in advance, and in particular we'll be looking at the remedies which are available under the Cape Town Convention if a state elects to do Alternative A. And this is a Cape Town devised agreement which provides for a common approach to issues of insolvency in aviation leasing and finance. There's only one slight hiccup in this, and that's what we're also going to look at. And I put that down as I didn't see that coming. And this is where, in fact, you think you've taken your security interest through the contract, you think you've protected your security interest against everybody else by registering it and therefore creating a priority. You've registered in a jurisdiction which has certified that or elected to take Alternative A insolvency process. Wait, what's that? Someone has taken another registration out which the debtor wasn't aware of. This is called non-consensual registration. It's where the International Registry accepts a registration of a charge without the consent of anybody else. We're going to look at all of these three things in turn. First, what happens if it all goes wrong? Spoiler alert, sometimes people don't pay back the money they borrowed. I know this will come as a shock to us as a people, but occasionally debtors don't fess up the money. I want my money back. How do I get that? Well, we have done in the first 3 sessions and in the materials which you've been given a way to do that. Basically, we're going to sue them in court for breach of agreement. It's a contract breach, fairly simple action. You borrowed the money, you agree to repay it back to me. You did not do so, so I go to court and get a judgment against you. I get the judgment, and then I'll seek to enforce the judgment. If I've taken no security, I will enforce a judgment by getting an execution against you, which will be an attempt to seize some of your assets or to garnish your wages. The courts are slow to do this, obviously. It will take some time and it's much more costly. In aviation financing, of course, since this is really all about secured lending, In parallel to getting a judgment, you'll also seek to realize the security which has been given for the loan. So, two-stage process. The first stage everybody relies upon. If there has been a breach of a contractual lending process, well, in that situation you go to court to enforce your judgment. Someone borrows 100 euros off you, doesn't pay it, well then you'd go down to court and get a court order. The court will make a ruling in your favor, and then once that ruling has been made, you can execute that judgment against the individual. If the individual refuses to honor that judgment, they may end up in jail, but more likely they'll end up with an order against their assets. Problem is, of course, this is long and expensive. That's why in aviation financing, and along with other secured financing, we take a security interest against a particular asset, in this case the aircraft. So in parallel, while you're doing this, you'll seek court orders to take possession of and control of the particular secured asset. This is on the basis that the other individual doesn't sell it, which is going to be difficult in any event, but more importantly, you can start the process of sale. Under Cape Town, there are a two-pronged approach to the remedies which you may seek to do. In other words, here a debtor is not paying their debt back, and now you seek to have the money restored to you. And you're doing that by realizing the asset. The two-pronged approach consists of this. First, there are basic standard remedies, and this provides a minimum baseline that is non-contentious. They effectively would be available in most national legal systems. And everybody who signs up to the Cape Town remedy certifies that they effectively have these remedies available already on the books in their national law. And I'm going to talk a little bit more about these general principles. The second, and these are more advanced remedies that states can opt in or out of. And what they're basically designed to do is to provide an enhanced system of remedies in aviation financing. So if, for example, I borrow money to buy an aircraft, a security interest has been created, well then every Cape Town signatory certifies that they have a minimum baseline of how that should be remedied through their national legal system. But Cape Town offers enhanced remedies, remedies which will suit creditors and therefore make it easier to lend. Remember, the easier you can realize your security, the more likely you're to find a lender. And these advanced remedies are things which the states can opt in or out of. There are differently held views, particularly on these newer type remedies. Some people think they're overly creditor friendly, some people think they're not. Generally speaking, opting in and out should be undertaken at the time of ratification, but it doesn't have to be done so. It can be done subsequently, later on, as we are about to do. And I've talked about this before, that when the UK ratified recently in 2015 the Cape Town Convention, it also elected that it would take a specific view with respect to enforcement remedies. We ratified Cape Town Convention 10 years earlier, yet we still have not yet finally given the decision, although we are in the process of adopting the same approach as that of the UK. Let's look at some of those general principles I talked about. And these principles, remember, are applicable to both situations. In other words, every signatory of the Cape Town Convention certifies or conforms to this particular outlook. First, it says that the remedies must conform with the procedure of the jurisdiction where it's being sought. So in other words, if you're seeking the remedy in the sense of trying to execute the security, well then you conform with the jurisdiction of that procedure. It's a service of notice, the court hearings, the documents which must be filed, the proof, and so on. These all go to the procedure, not to the substance of the agreement. 2, the jurisdiction must accept the freedom of the parties to extend additional agreed remedies, provided they're not inconsistent with the mandatory provisions of Article 15 of the Convention. This essentially allows for the parties to continue with the freedom of contract. So the parties should be free to agree additional remedies on the basis of a default, so long as they're not inconsistent with any of the mandatory provisions, and we'll talk about those in a minute. So first of all, in terms of general principles, the first two are easy. The remedies must conform with the process of the jurisdiction and where they're being sought, and secondly, the parties are of course free to extend beyond that. Thirdly, the remedies under the Convention must be exercised in what's known as a commercially reasonable manner. This is important, and it's a significant difference with respect to common law approaches versus, say, civilian law approaches. In common law, if you have breached my contractual right, well then I'm entitled to have that right vindicated, even if it's unreasonable. We don't care about fairness or justice or the impact of exercising the remedies. If the remedy is available to you at law, you are entitled to it as a matter of right. And this goes back to the Shakespearean play Merchant of Venice. An individual who has signed up to an agreement which says I'm entitled to a pound of flesh is entitled to exercise that right, even if doing so is acting unreasonably. This is not the approach taken in other jurisdictions, and the Convention gives reflection of that when you're exercising a remedy, you must do so in a commercially reasonable manner. You cannot, for example, say an individual who is 2 seconds late in the transfer of funds should automatically be considered in breach, subject to repossession of the aircraft. You cannot, for example, indicate an individual who has violated one small portion of an agreement, one small inconsequential part of an agreement, which has no real commercial relevance, should automatically forfeit all rights. Everything that you're doing must be reasonable, and what is reasonable will be determined by the commercial context, and in this case that is what is the commercial context within the aviation industry. Fourth, we'll talk about covers forum choice. And in other words, effectively, the parties can determine what jurisdiction the case will be heard in. This is exclusively a matter for them. It may be governed by the Cape Town Convention, the actual rule, but the forum that the parties have chosen will result in the exclusive jurisdiction of that forum. You cannot subsequently come along and start an action to have the case heard in another jurisdiction. So if we choose that the forum of a dispute is to be determined in an Irish court, we cannot subsequently come along and take an action in an English court seeking it to have jurisdiction. Finally, registered interest prior to the commencement of insolvency will take priority in accordance with registration. These are the basic issues. It's here, however, that I do wish to pause. Registered interest prior to commencement of insolvency take priority in accordance with registration. That has been a feature of the entire process. But there's something we need to note. Under Article 40 of the Convention, a creditor may register a non-consensual interest where a contracting state has made a declaration when they ratified the Convention. In other words, when the state is ratifying it, they have a chance to elect to either accept the concept of a non-consensual interest or not. And so they will opt in or out. If they opt out, then non-consensual interests are of no force in that state. If they opt in, however, which they may do so, it will have an impact. Declarations made under this article typically cover judgments or orders permitting attachment of equipment covered by the aircraft protocol and state liens for taxes and unpaid charges. Essentially what you're doing in Article 40 is elevating certain types of interests which arise more by statutory order. So for example, taxes, unpaid airport charges, and so on. These charges will take ahead of an a registered charge, which is ordinarily taken under the Convention. To show it's just as difficult to do this without a class, perhaps more difficult, I'm going to have another go at trying to explain this. And this simply is to say to you, look, what we're looking at here is certain types of debts, such as taxes owed to the state or unpaid airport charges. These which arise, in a sense, which are kind of regulatory charges. These charges effectively can be registered as an interest against your aircraft without your consent. And in that sense, they do take priority. They don't require your assent. They will appear on the registration certificate or the international registry, but they'll only be applicable where a state has actually permitted that to happen by declaring themselves to come within Article 40. They've made a declaration about this under Article 40. Compare this with Article 39, which permits the contracting states to declare certain interests as taking priority without registration. And this all boils down to the fact that the Cape Town Convention allows a significant amount of discretion on the part of the states with respect to elements of the convention. Remember, we said this, the convention really consists of two predominant parts, 80% of which are mandatory if you sign up, and around 20% of which allow the states to pick and choose certain elements. We've already seen that with respect to things like IDRA, the Irrevocable Deregistration and Export Request Authority. We will see it again, more importantly, with respect to Alternative A and Alternative B in the insolvency proceedings. And Article 40 and Article 39 are likewise giving the states choices. Article 40 gave it a choice with respect to regulatory charges such as taxes and airport fees. Article 39 allows for contracting states to make other interests have a prior interest without the need for registration. The other charges, Article 40, had to have prior registration, but it was non-consensual. It's almost like creating a lien against it on the international registry. Article 39 talks about this interest taking priority even though it's not registered. Article 39 liens effectively arise mostly from unpaid employees and repairers of the aircraft. So, for example, if there was a repair being done on the aircraft, if that money, the cost of that repair has not been paid, depending on the state you're in, that could constitute a priority interest, even though the cost of that repair is not registered, and it would take priority over a registered interest. Note, Article 39 and 40 are mutually exclusive. You cannot have both. You declare either Article 39 or Article 40. In the next section, we're going to look at a specific Irish case on this, Bel Air Holdings, and to look at the rulings, if you may like, made by the Irish court with respect to this.